Imagine working hard, providing excellent service, and then seeing your earned tips disappear or be significantly reduced. It is a frustrating situation that, unfortunately, many service industry professionals face. Understanding your rights regarding tips is crucial for ensuring you receive all the compensation you have earned. Generally, no, your employer cannot legally withhold your tips. Federal law, specifically the Fair Labor Standards Act, protects employees' tips, stating that they are the property of the employee, not the employer. This means that with very limited exceptions, your employer cannot take your tips or deduct from them. The reason for this protection stems from the Fair Labor Standards Act, or FLSA, which establishes federal minimum wage, overtime pay, record-keeping, and child labor standards. Under the FLSA, an employer generally cannot keep any portion of an employee's tips for any purpose, whether the employer takes a tip credit or not. There are strict rules around tip pooling. A valid tip pool can only include employees who regularly receive tips, like servers, bussers, and bartenders. Managers and owners are explicitly prohibited from participating in these tip pools or receiving any share of tips themselves. If you suspect your tips are being illegally withheld, the first step is to carefully document everything. Keep detailed records of your hours, the tips you received, and any discrepancies. Note specific dates, times, and amounts. Next, consider speaking with your employer directly. Sometimes it might be a misunderstanding or an accounting error. If that does not resolve the issue, or if you are uncomfortable speaking directly, you can file a complaint with the Wage and Hour Division of the U.S. Department of Labor. Many states also have their own labor departments that might offer greater protections and have their own complaint processes. An important concept to understand here is tip credit. Some employers can pay a lower direct cash wage than the federal minimum wage, but only if the tips received by the employee make up the difference, effectively bringing their total earnings up to at least the minimum wage. This is called taking a tip credit. If an employer takes a tip credit, they absolutely cannot keep any portion of the employee's tips. Also, be aware of mandatory service charges. These are not tips. If a restaurant adds a mandatory service charge to a bill, say for a large party, the employer has the discretion to distribute that money as they see fit, unless they explicitly state it is a gratuity that goes directly to the service staff. Understanding these regulations, especially those related to the Fair Labor Standards Act and state-specific protections, empowers you to ensure you receive all the compensation you have earned. By documenting your tips, knowing the rules around valid tip pooling, and understanding the difference between tips and service charges, you can effectively advocate for your rights and protect your hard-earned money in the service industry.